Hello, my name is Stephen A. Gravatt. In this, my second video about the New Jersey bail reform law that's scheduled to take effect January 1st of 2017, I want to talk to you today about the terms and conditions of pretrial release from detention while awaiting trial. In the first video that I made, I established this concept that there are two kinds of classes of criminal complaints. One is complaints issued on a summons, which would not require immediate incarceration, but would require that bail be set by municipal officials in municipal court. The second is a complaint issued on a warrant, which would enable, and in most cases require, municipal court officials, like a judge, to immediately take the defendant into custody, and the custody would then be shipped to the county jail for 48 hours, at the end of which, presumably, you would have a hearing before a Superior Court judge on the terms and conditions to be set for pretrial release from detention while awaiting trial. Now, why is this important? It's important because many people commit offenses that are not at the very far end of the spectrum that require or previously required jail. You know, things like armed robbery, things like murder, these types of offenses were always going to require jail with no bail or very, very, very high bail, some of them in the millions of dollars. On the other hand, suppose, for example, you're sitting at home one night with your wife and you have an argument. She alleges that you pushed her and calls the police. The police come over to your house. They find a vial of oxycodone sitting on your bedroom dresser. You don't have a prescription. Now all of a sudden, it's a third-degree felony, and for the possession of the oxycodone without a prescription. And then there's this assault charge, which is violent. And so the matter, say it happened in, for example, Freehold. So now, you're in Freehold before a municipal court judge who has to decide what to do. The law is going to require him under that type of circumstance to issue the complaint on a warrant, which means you're going to wind up in jail for 48 hours. Now the question is, when you get a hearing, what are going to be, if any, the terms and conditions upon which a Superior Court judge will allow you to be free, have your liberty back while pending trial for the third-degree felony of possession without a prescription of contraband, and or the domestic violence assault, depending upon how serious the assault was. If you broke her jaw, that's real trouble. If you just pushed around, that might be less trouble. But you can see the problem here. Many, many good people are going to get in trouble with this, that heretofore, previously under the old law, would be allowed to simply just post bail and go home until there was a trial. Okay. So when you start off with the proposition that under our state constitution, people are entitled to, a reasonable consideration of how much bail should be set in order to require someone to appear at trial for their proceedings. And what this means is this idea of flight risk is very important in the analysis. But there's a balancing act, because even if you're deemed to be, not very dependable, or you have a prior criminal history, you should be entitled to some freedom prior to trial, assuming you didn't commit a murder or an armed robbery or something of the like. So this is something that has to be negotiated with the prosecutor and the prosecutor's office. Now, there's also something else that needs to be negotiated, and that's the idea of whether the prosecutor will seek detainment while awaiting trial, or detention, I should say. And they're allowed to do that. They could say, well, this guy has a violent history. He had a prior Graves Act offense for having a handgun without a license. He's got oxycodone. He's dangerous. So we're going to say we don't want bail to issue. We want him to be in pretrial detention in jail until he has a trial. This could take anywhere from 3 to 6 months, even longer, while you're waiting for trial. So the terms and conditions of pretrial release are critical to negotiate during and at the close of the 48-hour period that the defendant is being held, and prior to the actual hearing, so that the hearing will go smoothly and the judge will have a good basis to decide what the requirements will be for the setting of bail, the posting of bail, and pretrial release. My name is Stephen A. Gravatt. I'm an attorney. I've been a defense attorney here in New Jersey for approximately 29 years. My cell phone number is 732-337-7922. I've handled many of these cases. If you need help, or you have a loved one or somebody in jail, after the first of the year, it's going to be much harder to keep them from being detained or held. But things can be done, and whatever it is, we can make it less bad. So please give me a call. I'll be happy to help you. Thank you.